Judgment in the appeal, the Queen on the application of Gujra against the Crown Prosecution Service.
Lord Wilson will give the judgment.
In August 2010, Mr. Gujra launched 2 private prosecutions in the Southampton Magistrates' Court. He alleged that the defendants had assaulted and unlawfully threatened him. In November 2010, the Director of Public Prosecutions took over both the prosecutions and discontinued them. In these proceedings, Mr. Gujra has sought judicial review of the DPP's decision to take over and discontinue his prosecutions. He says that the decision was unlawful because it was reached as a result of the DPP's application of an unlawful policy. The Divisional Court of the Queen's Bench Division of the High Court dismissed Mr. Gujra's application. Today, by a majority, this court dismisses Mr. Gujra's appeal. By Section 6(1) of the Prosecution of Offences Act 1985, Parliament preserved the right of a private person to institute and conduct a prosecution in all but specified circumstances. But subsection 2 gives power to the DPP to take over the conduct of any private prosecution, and it is agreed that such is a power which he can exercise in order to discontinue the prosecution. The DPP has developed a policy in order to enable him to identify the private prosecutions which he should take over and discontinue. His policy is to apply 3 tests. This appeal is concerned with the first test, which relates to the strength of the evidence in support of the prosecution. Prior to 23 June 2009, the DPP's first test was whether the evidence was so weak that there was clearly no case for the defendant to answer. If so, the DPP would take over the prosecution and discontinue it. It is agreed that, had such remained the first test in 2010, the DPP would not have taken over and discontinued Mr. Gujra's prosecutions. But on 23 June 2009, the DPP introduced a different first test. The new test is whether the evidence is such that there is a greater than even chance that the prosecution would result in a conviction. Such is identical to the test which the DPP requires Crown prosecutors to apply in deciding whether to institute a public prosecution. It was as a result of his application of the new test that the DPP decided to take over Mr. Gujra's prosecutions and to discontinue them. The main question in this appeal is whether it is lawful for the DPP to apply the new test in deciding whether to take over and discontinue a private prosecution. The answer given by the majority is that it is lawful for him to do so. Had it frustrated the objects of Parliament in preserving the right of private prosecution, the new test would have been unlawful. But the majority explain why, in their view, the new test does not frustrate them. It is, they consider, lawful for him to apply to interventions in private prosecutions the same evidential test which public prosecutors apply in deciding whether themselves to institute prosecutions. The majority also reject a second argument that the new test would be lawful only if it was so modified as to ask whether any reasonable prosecutor would conclude that there was a greater than even chance of a conviction. They also reject a third argument that it was irrational for the DPP to conclude that Mr. Gujra's prosecutions did not stand a greater than even chance of leading to convictions.
Court is now adjourned.